Everybody that has just joined in or has not, Brian Hine is going to be making a presentation to us. He's a former JAG Marine, and he's going to cover some of the Camp Lejeune water issues. So Brian, why don't you introduce yourself, give the guys a little brief background on yourself, and then go ahead and start your presentation.
All right. Thank you very much, Commandant, and thank you everyone for having me this morning. Like the Commandant said, my name is Brian Hine. I am a Marine. I'm a part of the Father Capodanno Detachment 1471 down on Long Island in Elmont. In a prior life, I was a 4402 judge advocate. Since getting out of the service, I've been working in New York as an attorney. I'm a New York attorney, mainly dealing with corporate and contract matters. But recently I've reconnected with some of the fine men and women that I've served with as judge advocates to get involved with a grassroots effort to educate and help Marines going through this Camp Lejeune water litigation to basically help stave off the unsavory ambulance chasers and the bad information that's being spread around. So I have a little presentation. I'm just going to share my screen here. Really the bottom line up front today is to educate you folks about the Camp Lejeune Justice Act. All right. I want to educate you folks so that you can educate in turn your troops, and people just have more accurate information about the litigation and what's expected of them if they are considering making a claim. The Camp Lejeune Justice Act, as you can see, is contained within the PACT-Act, and this was passed, I believe, August 10 of 2022, and it's Section 804. I will, let me see if I can go to the next slide here. All right. So, like I said, this is a presentation to educate and provide information. Brief ethical disclaimer: this is not, I'm not giving anyone here legal advice. Okay, this is not an advertisement for me or my firm. All right, this is just, and this is not a presentation just for Marines. This is a presentation for, as you'll learn, or you may know already, the Camp Lejeune Justice Act does not only protect Marines, it protects other service members and even civilians who may have been affected by what's going on at Camp Lejeune. So I will go through the slides, and then at the end, if there's time, I'll entertain any questions. I just ask that you keep the questions general. If there are individual questions that you have, or you know someone with individual legal questions, my contact information will be the last slide, and I can also put it in the chat, so we could speak offline about that. All right. So, and again, I'm part of a grassroots effort that's going door to door across New York State. And if you find this information helpful and you want me to come to your neck of the woods, I'm happy to do so and speak to your troops. All right. So let's start. What went wrong? A lot went wrong at Camp Lejeune over decades of time. Really, between 1953 and 1987, the government displayed a lot of wrongful conduct and reckless behavior. I have 4 bullets here that really talk about the most heinous of issues, and some of you may have already been aware of some of these things. For instance, at Tarawa Terrace, there was a dry cleaner that used to dump hundreds of gallons of chemicals used to dry clean clothes behind their store directly into the ground. After each month, they would do this for an extended period of time. Just so happens that dry cleaner was upgraded from the Tarawa Terrace drinking water distribution system. So as Marines, we know shit runs downhill. So do chemicals that are infiltrated into the water. And you can imagine some of those chemicals include PCE. All right. And we're finding the science connects PCE to several illnesses that people can contract if they have this in their system. At the rifle range, they buried approximately 50 to 55 unmarked drums of nerve agents from the World Wars about 5 feet below the surface without encasing them in concrete or any protective encasement. And those included, you can imagine what type of chemicals were involved with those, nerve gas and mustard gas. But you have Marines going to the rifle range multiple times a year, drinking from the water bowls there, filling up their canteens. That's another potential spot of exposure for these folks. There was at Hadnot Point, there was a major fuel spill, 20,000 to 30,000 gallons of fuel just right into the soil. And there also, at the time, during that time, over those decades, there was radioactive testing of dogs. They would test them on the base, pump these dogs full of radioactive ions, and they would just bury the dogs without any proper encasement. Again, so, compromising the soil, compromising the water supply. All right. So the government, after all this reckless and wrongful conduct, decides to do something about it after decades of lobbying for something. And they came up with the Camp Lejeune Justice Act. And this act protects not only Marines who were at Camp Lejeune, but those who resided, worked, or otherwise were exposed to the contaminated drinking water for at least 30 days. And that doesn't have to be consecutive days. I've met airmen who, over a series of years, would do laundry delivery to Camp Lejeune, spend the day there when they were picking up or dropping off laundry, drink the water, and over a series of years, they were there for over 30 days. That individual could potentially be protected by the Camp Lejeune Justice Act. And really, it pertains to those who were at the base between August 1st, 1953 and December 31st, 1987. And they have to have some sort of serious illness. Okay. The serious illness part, before I get into, I'm going to read through some of the pertinent sections of the Camp Lejeune Justice Act, and I highlight them here because all this information is available to you online. All right. It's a very quick Google search. If you just search the PACT Act, you look for Section 804. It's a very quick read. It's probably 3 or 4 pages. There's a little cross-reference here, which I'll explain in a moment to another statute. But the Camp Lejeune Justice Act is not a long thing to read. I encourage everyone to do that, especially if you're advising your troops on what they should do. All right. So before filing a lawsuit, everyone thinks the Camp Lejeune Justice Act is about a lawsuit. It does entail that, but according to 804H, all right, an individual may not bring a lawsuit under the Camp Lejeune Justice Act until they've complied with 28 USC 2675, which requires disposition by the appropriate federal agency. In this case, there's a little reference to just below in the second bullet, 28 USC 2675, saying that you need to go through the proper administrative channel first before you initiate the lawsuit. In this case, the appropriate federal agency to dispose of the administrative claim is the U.S. Navy JAG Corps. So what does that all mean? It's really, there's a 2-step process that these claimants need to go through. The first is, and you have to go one before the other. You can't jump straight to a lawsuit. The first is you have to file an administrative claim with the U.S. Navy JAG. All right. And what does that look like? Filing an administrative claim involves really a simple 1-page form. Now, this is, there's some important nuances to this form, which I'll go over in a minute, but this starts the process. All right. You need to file this claim form first with the U.S. Navy JAG before filing a lawsuit. If the claim is not resolved at the administrative level, then the onus is on the Marine or the claimant to file a lawsuit. And we'll get to that in a minute. But you can find a copy. The pertinent form for the administrative side is Navy Form 95. Again, another simple Google search, you can find a copy of this form. It's kind of hard to read what I have up here, but I do want to point out some important things. So there's been some articles through the VFW and other online publications saying that VSOs can help Marines with this process. They certainly can, and a Marine can do this on their own. But there's important language going back to that other statute, 28 USC 2675B. It limits the amount recoverable in an action to the amount listed on the administrative form. So you'll see at the bottom third of the form, there's a box 12, okay, that says amount of claim. On this form, you're identifying who you are as the claimant, the type of medical conditions that you have suffered, and you need to put down some sort of monetary damage that you're seeking from the U.S. government. The important thing to note and to tell your Marines is that what you put on this form is what the number that you're married to, and that it's the ceiling. So don't be selfless, don't be generous or modest. Okay, what you put on this form. Let's say if you have a Marine who develops Parkinson's disease after serving at Camp Lejeune during that requisite time period for more than 30 days, and they put for the amount of their claim on this claim form is $5,000. They later go to trial before a jury, and a jury awards them $1 million. They can only collect $5,000. Okay, on this form you set the ceiling, so make the ceiling high, so you're not negotiating against yourself. I don't know if VSOs are telling people about this, but that's something that they need to be aware of, and it's coming straight from the statute right there. All right, so once you file the administrative claim form, what can the Navy JAG do? They can do one of three things. They can accept the claim and make some sort of settlement overture to the Marine or the claimant. They can deny the claim, at which point, if they deny the claim, the onus is on the claimant to initiate step 2, which is the formal lawsuit. Or they can remain silent. If the Navy JAG remains silent for 6 months, the claimant may bring a lawsuit, and the only place you can bring a lawsuit is under the statute is the U.S. District Court for the Eastern District of North Carolina. That's the federal court down where Camp Lejeune is located. All right. So as of when this thing started out, Navy JAG only had 10 JAG officers assigned to handle all these administrative claims. There's a rough estimate, and I don't think it's the most accurate, but it's estimated that between 300,000 and 1 million potential claimants are out there. Okay, people who have gone through Camp Lejeune during that time period who may be able to file a claim. So you can imagine if Navy JAG keeps only 10 officers there, and there's hundreds of thousands of people that are going to be filing claims, they're probably going to be inundated with paperwork, and they may, more times than not, remain silent when people file their claim form. So you got to tell, I would advise your Marines of that, tell them not to get discouraged or frustrated. It's just they got to be prepared to, if they're doing this, to really get ready for step 2, which is filing the formal lawsuit. And just to give you a perspective, as of 2 weeks ago, rough estimate, only 15,000 claim forms have been filed with the Navy JAG so far. So if we're talking about hundreds of thousands of folks, a vast majority haven't done anything yet. So let's go to step 2. You've done the claim form, you filed it with the Navy JAG, either they denied it or they remained silent. Now the onus is on the claimant to bring formal litigation in the Eastern District of New York. And there is straight from the statute, the Camp Lejeune Justice Act, there is a deadline or a statute of limitations for the litigation. And this is in 804 subsection J. It says a claim and an action under this section must be commenced by the later of, all right, within 2 years of the Camp Lejeune Justice Act. So that went into effect on August 10th, 2022. 2 years would bring it to roughly August 10, 2024, or the date that is 6 months after the date on which the claim is denied by the Navy JAG at the administrative level. So really, what it's unclear right now how long. So you have to, of those two letters A and B that's on there for the statute of limitations, you have to go which one is later. That gives you the time frame of when you can file the lawsuit. So it's unclear right now how long the U.S. government, the Navy JAG, will be accepting claims forms. So it's unclear whether they'll go beyond this August 10, 2024 date. So it really, it's something that the Marines, the potential claimants, need to be aware of. This window of opportunity may not be open forever. And if they're going to file a lawsuit, let's say the drop dead date, they stop allowing claims next year, hypothetically, let's say that happens, then really, you're left with 2 years after the Justice Act was enacted. And that gives us to August 10, 2024. If you got to wait 6 months for Navy JAG to respond, you really need to kind of get your claim in by Q1 of 2024, right? This is just hedging your bets and trying to make sure that you're getting your claim form on time. The one thing that I find interesting about the statute of limitations for litigation is that with this statute coming into effect, it's really opened the door for wrongful death claims where Marines meet the requirements of the Camp Lejeune, being there for so long, contracting a serious disease, but died several years before the Camp Lejeune Justice Act was enacted. This reopens the door for a wrongful death claim where perhaps if the statute wasn't enforced or wasn't enacted, I should say, they may have run out of time under the normal operation of law for their statute of limitations. So it does create another block of time for those types of cases to file a lawsuit. So you filed the lawsuit, okay? The statute says that the burden of proof is on the claimant bringing the lawsuit, okay? The one who's filing the action. And there is a burden of proof. You have to show certain things, right? So you see here the standard: you must produce evidence that the relationship between the exposure to water at Camp Lejeune and the medical harm, that it's either A, sufficient to conclude that the causal relationship exists, or B, sufficient to conclude that a causal relationship is as least as likely. What does that mean? All right. So the burden of proof, okay, this is not a class action right now. The statute makes it individual Marine, John Doe Marine versus United States of America as the caption of the lawsuit, because the thought is that everyone suffers their own unique medical conditions or has their own unique medical conditions, and you cannot necessarily lump folks with different medical issues into the same case. And in fact, the judges down in the Eastern District of North Carolina have recently said that they won't even consider consolidating plaintiffs who have similar medical conditions together. They want to do one case at a time. And the plaintiff, the claimant, will need to show that they were at Lejeune for between 1953 and 1987 for at least 30 days, that they suffered some sort of medical condition, and they have that causal relationship in that, and that's that as least likely as not language, which, is confusing language. I mean, as an attorney, how I potentially read that is I see it as kind of a coin flip. And I would, if I were arguing potentially in front of a jury, I'd say, I give a hypothetical, right? If you have a Marine who was at Lejeune and they were there for the requisite amount of time, they later get out and they develop a nasty drinking habit, okay, alcoholism, and then later contract kidney cancer, and they file a lawsuit in this Camp Lejeune matter, what caused the kidney cancer? Was it the exposure to water at Camp Lejeune, or was it the years of excessive drinking? If it's a coin flip 50-50, if it's as least likely as not that the cancer was caused by the water exposure as it was to excessive drinking, then I think that plaintiff has met their burden. And that's how I would equate it. It's like a 50-50 coin flip. All right. If there's potential multiple reasons for that condition, and then you can argue that you've met that causal burden of proof. All right. One of the biggest questions I get is regarding VA disability benefits, and the easiest way I think to address those questions, if you may get them from your troops, is to point again to the statute. It's all right there. Offset is really what folks get worried about when they see these TV ads and hear these radio ads and get this spam emails. They're worried that their VA disability benefits are somehow going to be affected. Under Section 804(e)(2), it says that any litigation award that's award from a jury or some sort of settlement during the litigation, right, shall be offset by the amount of any disability award, payment, or benefit which relates to exposure to water at Camp Lejeune. So what does that mean? If you have a Marine who's received VA disability benefits, some sort of monthly payout or something else directly related to Camp Lejeune water, let's say they received $100,000 over the course of their life for VA disability benefits just related to Camp Lejeune water, and a jury later awards them $200,000 in the litigation, that Marine may only collect from the jury the difference, the $100,000 difference. So that you can't double dip, essentially. Now, if that Marine also has VA disability benefits for their knees and back that they injured while doing the things that Marines do, those benefits should not be affected. And this is again, there's some publications, some nice pamphlets that the VA has put out about this, which say essentially the same thing. And if you'd like, I do have copies of those, and I can email those out after we're done here today. So I will turn it over to questions. I do want to say just one more thing. Here's my contact information. I could put it back in the chat. If anyone has any questions at any time, you can give me a call. That's my cell. That's my email. But really, I think that the impression that I'm getting is that there's a lot of scare tactics out there on the street from these, some of these attorneys on TV and radio, and the spam emails. It's causing people to get frustrated with the process. It's causing inaction, when, as you could see, that there really is a timeline for this thing. And, it's not the government funds that are set aside for this are not like the 9/11 fund. The other thing I get is that Marines are very selfless people. They are always thinking about others before themselves. And a lot of folks who have, serious medical issues that may be related to Camp Lejeune, they are hesitant to file because they think they're going to potentially take away money from someone who's more deserving. It's not like the 9/11 fund where there's a cap. Okay. Rough estimate. I think for the PACT Act, okay, that's including the OIF folks, they set aside 39 billion. I think 6.9 billion of that 39 is set aside for Camp Lejeune. And there's nothing that I know of that says that there's any cap there. So it's not like the 9/11 fund. I know the Department of Justice is trying to trying to make it more like the 9/11 fund in terms of a cap, but I don't think anyone is going to agree to that. The other thing I wanted to say is that look, I mean, there's a presumptive list of illnesses that the VA has put out. That list, as the science gets more exact, one can imagine that list will be expanding. So if your Marine has a condition, it might not be as severe as some of the cancers and other heinous diseases that are listed on that presumptive list. You may want to encourage them still to file and preserve their rights. I mean, let the government tell them no. That's my kind of view on it. At least they can rest assured that they tried something and they didn't sleep on their rights. So I've been talking a while. If there's time, sir, I'm happy to take any questions.
Yeah, Brian, you've got all the time you need. This is scheduled for another 15 minutes, but I think we've even got a little bit longer than that if we need it.
Okay. All right. I'm happy to take any questions. Thank you very much.
Thank you, Brian. Appreciate it.
Brian, Mike Wallach, Northeast Division Vice Commandant. When filing the claim, if you win, I'm hearing conflicting stories where, and this is all alleged, but if a person files a claim and they win, should their condition worsen, okay, they can no longer collect any benefits that they're collecting from the VA due to this. But worst case scenario, if they try to do that and there's a return of money, are they responsible for also paying that full amount? So if you won, say, $500,000 in suit and the lawyer takes 40,000 of it, or, and I'm using that just as an arbitrary number, do you have to pay all that money back as well as the lawyer's fees in order to get the VA to continue the benefits?
Yeah, so I think I understand your question, and I want to try and speak as clearly as I can. So if I'm unclear, please let me know. But so this is a case of first impression in that I don't think we've seen any. There've been lawsuits on this for a while, and they're just kind of getting started on doing that. So it's going to be interesting to see how it all plays out. But with respect to VA disability benefits and receiving a lump sum from either the government in some sort of settlement or from the jury, right? If you only would have to pay back, and it's not actually a payback. It would be, let's say use your example, $500,000 is awarded. Okay, there's only offset if that Marine got some sort of payment before, in the years before, from the VA related to Camp Lejeune water. So let's say that in that same hypothetical, they received $100,000 from the VA just for Camp Lejeune water. So that'll be known to all the parties in the litigation, to the judge as well. Okay, the jury comes out, they say, Your Honor, we award this Marine $500,000. Okay, and the jury is asked to leave, and then the judge sits down with the U.S. attorneys and the plaintiff's attorneys and says, okay, $500,000 is the reward. The judge gives the thumbs up on that. We have to factor in that this Marine received $100,000 from the VA. So U.S. government attorney, would you just like to, just deduct from the $500,000 the $100,000 and just give the Marine $400,000 right now? Or, do the parties want to work out how they want to, get that remaining $400,000 rather than the Marine getting the $500,000 has to write a check back to the government, that kind of, that seems like a roundabout way of getting to the same thing. It's going to be interesting to see how that all plays out. Whether the U.S. government will also have someone from the VA at their table as well to help negotiate, like, for instance, if there's settlement negotiations, to negotiate how to pay the Marine, whether that's lump sum or over time or an increase in percentage. That's something that I imagine could be negotiated between the plaintiff's counsel and the U.S. government. Does that answer your question?
Yes, sir.
Okay. All right. It kind of brings me to another point. Yeah, go ahead.
No, but I was thinking, Mike, as I was listening to your question, correct me if I'm wrong, but you were saying once the award is made and the VA has been taken the offset, if his condition worsens to the point where he and let's say for the example that's been stated, he had 500,000, the VA took their 100,000. Now his condition worsens and the VA, he continues.
I don't know.
Expenses, if his expenses increase, I mean, is he limited right there at the 400,000? I mean, is he gonna have to pay out of pocket?
Yeah, so I think that once you file your lawsuit and you get some sort of award or some sort of settlement, if there's a settlement, right, there's going to be a release of all future liabilities, I imagine.
Okay.
So if the condition worsens, you can't go back for a second bite at the apple against the US government.
Okay.
And there's something called judicial estoppel. And if it goes through the lawsuit and it's been decided by a jury that, this Marine had X type of cancer, it's worth Y type of dollars, and that Marine is getting Y type of dollars, and the cancer becomes even worse after that, they can't go back at a second bite of the apple. So but as a plaintiff's attorney, what you would do is you'd say, okay, this is my client, John Doe Marine. He has X type of cancer. We can imagine we're going to, they would have some sort of experts that would talk about the life expectancy of that Marine, how with medical experts, how the cancer could get worse, and that the jury needs to factor that in. That's going to affect the Marine for the rest of their life and potentially get a lot worse. And that you need to assign an appropriate dollar figure to account for that potentially worsening condition. So that's ways that, for that, in that hypothetical, that Marine can kind of protect themselves.
But that's all got to be argued prior to the award.
Right.
Gotcha.
Yeah,
Okay.
so
Brian?
again, the understanding is once the award's made, that's pretty much about it. There's no going back or digging deeper into the well, as Brian was just saying.
I mean, there may be at some point a second opportunity if there's new legislation that potentially amends this, but I'm not seeing it right now.
Hey, Brian, Michael Piscotti, Judge Advocate. Just a quick question. With that being said, at the first court hearing, if they award so much more because of potential lifelong disabilities and so on and so forth, can the VA or the person take that sum of money and put it in a trust if they go over the amount? So let's say the amount was $100,000 and the lawyer fought for more because of lifelong illnesses after this court hearing. Can they take that money and put it in a trust for medical use later, so it's non-taxable?
I'm again, speaking hypothetically, I'm sure that if that's what the Marine would like to do, they'd have to get with the attorney, their plaintiff's attorney, kind of set that game plan up, and possibly speak with another trust attorney, like who manages medical trusts, possibly an accountant, and try and work something out to make that happen. Do I think it's possible? Yeah. Have I ever done it myself? No, but I'm sure that there are people who have done something like that. I'm not saying it's impossible or anything like that. It's hard to kind of imagine, speaking hypothetically, what that looks like.
Okay. Thank you.
Al Hazard here, Southwest Area Vice. I'm just wondering if a Marine filed a suit and won because of a cancer A condition, and all of a sudden another medical condition that is related to, or could be related to, the water there at Camp Lejeune, could they file again for that second condition?
I don't know. I don't know the answer to that. And the reason being is, like I said, if their initial case with their initial cancer plays out in settlement, I would imagine that the U.S. government attorneys would require in that settlement some sort of release language, which says that the Marine, for whatever reason, cannot come back and sue the government again for any type of illness. That would be something like a general release, and the Marine would have some sort of language protecting them, that the U.S. government won't go after the Marine for anything related to Camp Lejeune. That's typical settlement agreement language that's in there, and it's really, you also have to think about that statute of limitations language that I showed you earlier in the presentation, right? We don't know how long. So the hypothetical that you're talking about, right? The Marine would need to file another claim form with this new condition, and we just don't know how long the government will entertain those types of claim forms, right? So, and again, folks, I'm happy to answer these questions. These are all good questions. I apologize if I'm vague or I don't have an exact answer for you. This, like I said, this is a case of first impression. We're gonna, I'm happy to come back and talk to you folks about updates in the law and what we're seeing on the front lines in terms of litigation. I think because of the amount of potential claimants here, and the numerous illnesses that are related to this water contamination. I mean, these cases can go in almost an infinite number of directions, each unique from the other. So I apologize if I'm not giving you the answer that you're looking for.
I think you hit the nail on the head. Don't be bashful when you fill out that first form and claim the your ceiling. I mean, obviously, someone with a cancer, a bladder cancer, and the cancer metastasizes to other organs, you've got more, you've got obviously more issues, but if they're not gonna, like you say, if the time frame is expired, once, that stuff is discovered, you're pretty much done for, so.
Yeah.
May I ask?
Go
I'm
ahead.
sorry.
Go ahead.
I was just going to say that the question that I've heard over and over again, and I don't know the answer to, is what if somebody's already receiving their disability and considered at 100%? If they get some type of settlement, I'm sorry, Donna Hildebrandt, Chief of Staff, if they do happen to get some type of settlement, are they putting their disability that's already been awarded in jeopardy?
So again, I think this goes back to the offset. The way I'm receiving your question is that the Marine has 100% disability. And are you saying 100% related to Camp Lejeune water?
No.
Okay, so
No.
let's say 10% of Marine has 100% disability. 10% is related to Camp Lejeune water, and they've received some sort of money over time before they get to the jury or the settlement talk with the government, which, however, this thing is resolved. And the Marine is later awarded money above and beyond what they've received for that 10% to date for Camp Lejeune water. They will have to sit with their attorney and say, okay, how do I want to receive this money? And what's the offset look like? And the other 90% of the disability is not going to be affected.
So if it's 100%, if they've, I'm sorry, I interrupted.
No, and it's going to be, it's going to be interesting to see how that 10% is resolved between the plaintiff's attorney and the U.S. government and the VA. So are they going to, is what the jury awarded above and beyond what the Marine have received to date, is that the end all for that 10%? And that's what the Marine is going to get for the rest of their life? You know, or is it going to just be, you know, the monthly payment for that 10% is going to remain intact and they're getting money on top of it? I don't know. But that's something that, you know, there's been a couple congressmen on the Hill that have been talking about, you know, people not getting an attorney to do this, just relying on your VSOs. You could certainly do that, but if you, I think that that's not really practical advice or guidance from Congress. This statute, as you see, is laid out in a way that you have a burden of proof, and you know, you really need the help, unless you're, you know, very savvy and you've done litigations before as a pro se litigant. You really need the help of an attorney to try and do this. You can certainly do it on your own. No question, you can do it, but it's just a lot of work. If you think you need help negotiating with the U.S. government attorneys, you know, potentially, you know, getting in talks with the VA, and then preparing and filing a complaint in federal court, going through the throes of discovery, you know, that's document exchange, depositions, retaining medical experts, engineering experts, and then arguing to a jury. You probably need an attorney to help with that. The DOJ, Department of Justice, the U.S. attorneys, you can't walk into this thing thinking that they're just going to fold and just start paying money to people. All right. I think that they're going to, I showed you that map of Camp Lejeune and the various areas. The contaminants that were involved over those decades, they're at different locations on the map. I imagine if I were a U.S. attorney defending the U.S. government, I'd say, okay, where was this John Doe Marine? He was at Hadnot Point. What were the contaminants that were located at Hadnot Point? They were 1, 2, 3. He has a disease that doesn't relate to contaminants 1, 2, 3. So, you know, there's no causation there. They're gonna try and do something like that, you'd imagine, to try and save the government as much money as they can, because, you know, but at the same time, you know, I also think like how you know, this reckless behavior and wrongful conduct is so heinous. Like, how could they really, you know, litigate all these, spend all those resources on fighting, you know, people who served selflessly for their country and have, you know, have all these serious medical conditions. So, your question just reminded me, I wanted to hit that point that, you know, you can do this on your own, but I think it's kind of out of a majority of people's houses to do this.
Hey, Brian, with what you just said, wouldn't it be feasible then to go before a jury of your peers and let them make that decision? Because, you know, a jury, in my eyes, I would see them as saying, okay, well, Joe Schmuckatelli was a Marine veteran. He fought and kind of, like, pardon the language, screw the government. What's your thoughts on that?
You're saying, well, I apologize if I misinterpret the question. I think that, you know, because we're talking about hundreds of thousands of potential claims here, it's really inconceivable for the government to actually fight everyone, right? You're going to have, you know, before 6 judges, you're going to have, you know, 500,000 lawsuits. They could do it. They could, but I imagine at some point they're going to have certain bellwether trials, find out what a North Carolina jury of our peers, or, you know, would say an award. And North Carolina jury is very different from a New York jury. I'll tell you that. They, you know, they're probably a little bit more service oriented down there, and a little bit more, you know, not to knock New Yorkers, but you know, as you go south, they tend to be a little bit more favorable to service members.
We've got a lot of bases. We got more Marine bases in the Carolinas than probably any other region of the country. So
Right. So and I mean, if people learn about this, just things, you know, the radioactive testing of dogs in the rifle range and just the dry cleaning, all those stories, they're going to get exercised. They're going to be a little, you know, indignant and mad. And I think that they're going to, you know, they're going to find the plaintiffs to be, you know, as a plaintiff's attorney, you would want to present, you know, their service history, what they do, you know, that they're good, upstanding people, right? And introduce them to the jury. I think a jury might, yeah, they might, you know, give some favorable verdicts to these plaintiffs. And I think that once, you know, again, case of first impression, once the plaintiffs bar, the U.S. government attorneys and these judges kind of see how a North Carolina jury is shaken out for various illnesses. You know, they've done 3 or 4 Parkinson's cases. They kind of get, everyone involved is going to get their left and right lateral limits about what a Parkinson's case could look like in terms of money damages. Same thing with, they do a couple of brain cancer cases or, you know, kidney cancer cases. They're going to kind of understand where that jury of your peers lands. And then they may say, look, you know, it might be more cost effective to just kind of silo different cases into buckets of medical severity and try and do some mass settlements. They may be doing that. I don't know. It's very unclear right now. And I want you to know that, you know, my crystal ball isn't perfect, but that's kind of where it could go in my mind. I hope that answers your question. Good.
So Brian, back to Donna Hildebrand here. We
Yeah.
were talking about the 90-10. I was referring to, let me just make sure I understand you correctly. The 90% that somebody's already receiving, okay, that's not going to be touched at all. It's not in jeopardy.
It's not in jeopardy.
Okay, thank you.
Okay, and I can email you I put my email in the chat. Okay, if you didn't jot it down. If you want to send me an icebreaker email, you folks, I can I have a very nice user-friendly VA form, which they say that it's not going to be effective. Okay.
Thank you.
Great. Any other questions? Brian, the only thing, great presentation, and I thank you for taking the time out of your day to make this presentation.
Yeah, that's fine by me. Like I said, well for the time.